Howdy troops, it's Maro here again, and today we're going to be dealing with the case of Sheridan and Pact Group. This is a medical incapacity conversation. The employer is ultimately found to have dismissed the employee lawfully and appropriately, and it gives us a really interesting insight into how to approach these sorts of matters. Basic facts look a little bit like this. There's a gal, Miss Sheridan. She has an accident sort of January, February 2021-ish. It doesn't go spectacularly well, obviously. She's out on leave, she's out on sick leave, she's engaged in ACC. There are a series of medical certificates, not always very clear, some of them open-ended. There are a number of discussions with various medical practitioners come professionals, not all of them always clear, all reported back to the employer, and the employer is left sort of having to manage periods of absence, not necessarily knowing when or whether they'd come to an end or be replaced with another. Effectively, it does this for roughly 6 months, and then comes to the point where the old medical incapacity process needs to be undertaken. They do this really well. They write to Ms. Sheridan. They basically ask for a prognosis rather than a diagnosis. So not a conversation about what has happened, but a conversation about what's going to happen. What do you have? What is the likely time frame for your ability to recover from that, return to work on light or limited duties, maybe in some other kind of role? How can we have some confidence, and how do we work with you to bring you back into work? That process is put to her. She does not, for various reasons, participate in that as fulsomely as she might otherwise wish or be able to. As a result of that, the employer is forced to make some decisions based on the information it has to hand. It does so and terminates her employment in August. There is obviously a claim brought, and the basic elements of the conversation are, as far as the authority is concerned, look, the employer did the best they could. They've put up as best they can with the absence of this person. They've covered in an interim basis for as long as they can, but you can't interimly cover a long-term role for any longer period of time than probably the 6-month mark that they did. Also, and additionally to that, we know that they genuinely attempted to engage with Ms. Sheridan, but there wasn't necessarily a lot of engagement back with detail, with information that supported a sense of comfort and confidence about the return to work, or any kind of ability to predict or manage the workflow itself. So, as a result of that, there is a determination that ultimately the decision to dismiss is reasonable, that medical incapacity applies, and that there is no claim here to answer. Folks, for us, I think this demonstrates two things. Firstly, any medical capacity program or complaint or activity is something you only undertake when you've got a really strong set of evidence and activity to say you've tried to manage your business while this person has been absent. I doubt there'd be many circumstances where less than 3 months would be available to you, and I kind of feel like that 3 to 6 month mark tends to be the mark that the courts also would start to think, yeah, that's pretty reasonable. The size of your organisation and the importance of that role will obviously move some of those factors around, but I think the key message here is you have to really show you've tried really hard. And the other thing I would say is, once you're in that process, you have to genuinely create the opportunity for someone to engage and consult with you, but that doesn't necessarily mean you can't make a decision if they choose not to. Ladies and gentlemen, boys and girls, it is as always my great pleasure. Thanks very much for joining me, and hopefully we'll see you again soon.